This is something that judges don't speak about much, and therefore the public doesn't know about much, that judges are expected to be multitaskers. It is, of course, a myth that outside of the court working hours, judges have a jolly good time. Most of the judges, and at all levels, are working beyond court hours, attending to administrative tasks. And what are these? Examining building plans for new courtrooms, purchasing computers and furniture, choosing uniforms for staff, examining complaints against judges in the district judiciary, deciding whether to order an inquiry, fixing the menu for the next grand event being hosted by the court, preparing for lectures to deliver at judicial academies. I became a judge in May 2006. I was fortunate that the senior bench partner was Justice Mukul Mudgal, somebody I had known from the bar days. And he mentored me for the first few months. And within the first 10 sittings, he'd asked me to draft a judgment. So I was very excited. I prepared the draft, and it was around 4:30 or 4:45 in the evening. We had got off the bench at around 4:15. So I knocked on his door, opened it because I wanted to show him the draft. And I find Mukul sitting in his chair and holding a plastic mug like this. So I said, Mukul, what is happening? He said, Buckets and Mugs Committee. So 3 judges of the High Court sit on the committee to decide what towels to buy, what plastic buckets to buy, what mugs to buy. Basically, the buck stops with the High Court judges. And you're supposed to have a working knowledge of all of this, which computers are good, and which food tastes good, and from where, who should be the caterer. You know, the support staff will prepare the background papers for you, but ultimately you take the call. And so from the most, banal to the most, grave, you're supposed to have the answers for many of these administrative tasks. For district judges, all this and having to be on high alert not to displease the boss, who's the High Court judge, who has to write your annual confidential report, the ACR. There are growing instances of women judges facing the trauma of sexual innuendos and harassment at the hands of male colleagues. We are yet to devise satisfactory mechanisms of fairly dealing with these complaints. We should remember that all of this applies to court staff as well. So when you have news items that, this High Court judge sat till midnight, that High Court judge sat till 2 a.m. in the morning, we seem to forget that the judge has a supporting staff, which have to stay back at least 2 hours after the judge leaves to wind up the actual court proceedings. So it is a big punishment on the court staff if a judge chooses to keep working beyond court working hours. And it's a myth that the judges in our district judiciary are actually independent. They're anything but. They're totally dependent in their day-to-day functioning on the cooperation of the local police and the local administration. They issue so many warrants for production of the accused, for production of witnesses. If the local police doesn't cooperate, nothing can move in your court. In sum, our judges and their staff in the courts have always been overworked, punching way above their collective weight in working conditions that are far from ideal. So then, who else contributes to the delay in disposal of cases? First and foremost, as all lawyers in this room will know, the state, by which I mean the governments both at the states and the center. By taking arbitrary decisions, or by not deciding at all, or by unthinkingly criminalizing normal activities in a democracy like peaceful protests and unnecessary arrests, government drives the people to the courts. This explains why, despite the delays, costs, and uncertainties in the court system, the filings have grown over the years. The other problem is that the state's capacity to litigate can outmatch even the richest conglomerate. If the state loses a case at any level, it will appeal and keep doing that till the Supreme Court. It could be an increment of 100 rupees given to a Mali in a government department, or a pension of 300 rupees to a widow of a deceased government servant. Everything has to be appealed. And if the private individual succeeds, there is no guarantee that the government will accept and comply with the court order. The contempt roster in our courts is burgeoning. Repeated litigation policies of the state have remained on paper. There is simply no will to implement them. The lawyers engaged by the government are also to accept the blame to some extent, because it is they that advise the government on the next course of action. The fear of being blamed later for favoring an individual litigant makes both bureaucrats and government lawyers to play it safe and advise going in appeal. Also, since the fee is low and tied to the volume of work, there is an incentive to keep filing cases, however frivolous. At another level, government will not employ enough counsel and on time and hand them the relevant records and instructions. So often, as private lawyers, we've been asked by those appearing for the government to give them the copies of the papers because they simply don't have the copies of the papers. Many of these appointments to the government panels are distributed as largesse with no real relevance to the expertise required. All this leads to numerous adjournments on account of non-availability of the government counsel, whether as a public prosecutor, a government pleader, or a law officer. If they do appear, they are instructed poorly or not at all. Reply affidavits are seldom filed in time. Records are never produced within the time stipulated. And judges at all levels are helpless. They can be frustrated, but they can't move without the government producing the records. And they are forced to accommodate these requests. All this can and has to change if there has to be in 2047 a better functioning judicial system. Then let's talk of the private lawyers. They fare no better. In the marketplace of lawyers, 80% of the work in any court is with 20%, if not less, of the lawyers in that court. At the level of the district judiciary, especially in the remote towns and districts, full-fledged trials of civil and criminal cases rarely take place. There is an increasing tendency to only argue interim injunction applications in civil cases and bail applications in criminal cases. If an eyewitness stands firm and cannot be won over, the lawyers will find ways of deferring the trial. In a court of a junior division judge, the local bar can be domineering. A judge who refuses adjournments is unpopular, is labeled as arrogant and insensitive. Strike calls are given over trivial issues. Most lawyers who practice in these courts have other avocations to keep their income flowing. And we have a Bar Council of India and Bar Council in the states that are reluctant to hold inquiries into complaints of professional misconduct and in good time. These lawyers also resent the provision of free legal services, mediation, and appointment of salaried defense lawyers employed by the legal services authorities. But not everything is so dire. Just like there are a few judges at all levels who are conscientious and consider themselves accountable, there have always been, and I'm sure there will be, a relatively small number of lawyers, almost in every bar, who view the legal profession more as a service to society and less as an opportunity for career progression. These lawyers take up cases at reduced or no fee and sometimes offer their services pro bono. This is apart from the panel lawyers of the legal services authorities, which is the state-funded public arm of institutionalized legal aid. We have had and continue to have private lawyer collectives and civil society organizations offering free legal services. I think the best example we can give is the person sitting here as chair, founding the Lawyers Collective, which has rendered legal services. Then we've had Justice D.K. Basu. Yes, the same Justice D.K. Basu of the D.K. Basu versus Union of India fame, who headed what was known as the Legal Aid Society of West Bengal, LawSweb. Then we have had the Jagdalpur Legal Aid Group headed by Shalini Gera. We've had the Majlis, Flavia Agnes's organization in Bombay. But more recently, in National Law University of Delhi, there was Project 39A. It still continues, but the Project 39A, when it started, was an offshoot of the death penalty project. And it had a team of young lawyers completely dedicated and committed, visiting prisons all over the country, unearthing stories of convicts on death row. And they've had a fairly good success rate in the Supreme Court. And that good work continues today, hosted in Nalsar. It now goes by the name of Square Circle. So these are very inspiring stories. These are good examples of young lawyers, and they can be emulated. And it is for the Bar Council of India itself to encourage other young lawyers to follow this example. The Supreme Court has on the judicial side been attempting to bring about reforms in the functioning of the Bar Council of India. The present CJI is taking special interest in this. But for the changes to be lasting and consistent, the changes must come from within and follow a democratic process. A bar controlled by the judiciary does not augur well for either the bar or the judiciary. It is good to see that a protest that started in Jantar Mantar has had ripple effects, and hopefully the dispensation in the Bar Council of India will also wake up and introspect about the number of changes that are required to make that body more responsible. A vision for the bar of 2047 is this: a reformed Bar Council of India that is democratic in its functioning, insulated from interference by the executive and the judiciary, responsive to the needs of the litigant public, prompt in dealing with complaints of professional misconduct by lawyers, and an upholder and to encourage upholding of constitutional values and human rights. It is time to acknowledge that the present system of having the Bar Council of India determine the course of legal education has not worked. And that is what I'd next turn to. It is trite that for a better crop of lawyers and judges, we need better qualified law graduates. Despite 4 decades of national law universities, not all of the law graduates passing from there are entering the field of litigation in courts. Corporate offices and firms are still more attractive to most of them. Those that have passed through the NLUs or have done a 5-year or 3-year course from the premier legal institutions and choose to litigate are discernibly infusing quality in the bar. And as having sat as a judge for 17 years, I'm able to sense that with these young lawyers coming into the bar, the quality of the bar is certainly improving. Their internships during the student days have exposed them to the workings of the legal system and have prepared them better to take on the challenges of the legal system. Yet, it is a cause for concern that the quality of legal education in the country is not uniform. There is a growing gap between the top-ranking law colleges and those that constitute the vast majority of the rest. That legal education is in the control of the Bar Council of India has not helped. Even the utility of having sitting judges of the High Courts and the Supreme Court in the governing bodies of the national law universities needs a rethink. It is time to decouple the link between the Bar Council of India and legal education and set up a truly autonomous body for legal education that can set minimum standards that are not diluted in their application. With students being better equipped than their teachers in many of the national law universities, there is a mismatch and there is growing disenchantment and discontent. You find students protesting about the abysmal conditions in many of the national law universities that do not feature in the first 10 ranks. The vision for the law student is this: students who are taught to fight against injustice and who have imbibed constitutional values are more likely to be fearless and independent lawyers, and they in turn will hopefully be the lot from among whom our judges will be chosen. So there have been various attempts at legal reform in the past 79 years. The 3 evils that have plagued our formal legal system are costs, delays, uncertainties. There have been numerous commissions and committees apart from the Law Commission of India. We've had a national court management system, the NCMS. We have its counterpart in the states. We also have the E-Committee of the Supreme Court. We have the E-Courts Mission Mode project that it is monitoring. So one thing is clear: we do not need any more commissions or committees. I suppose all of you know the 11th commandment. The 11th commandment is thou shalt not committee. There is already enough material for all of us to study and act upon. So we've tried special courts, we've tried fast-track courts. In fact, when the tweet of the Prime Minister was made public that he's going to set up fast-track courts to deal with, paperly cases, many of us realized that it's going nowhere. Because the same existing judges are simply designated as special courts. The same existing judges are designated as fast-track courts. The same existing judges are designated as commercial courts. It's just like wearing a different hat. If you go to a place like Meghalaya, it's the same judge, the same individual judge who's the commercial court, the special court, the CBI court, the court for MP-MLA cases. So we have a great flourish. We do this with great flourish, thinking we've solved problems. We've actually compounded them for the judiciary. Then we have had tribunals. The late Professor Mark Galanter had a lovely way of describing this. He said this creation of tribunals is like creating, bypasses where you divert traffic from the highways. The tragedy in India is very soon those bypasses get choked and all the traffic in the bypass goes and comes back to the highway, which is already choked by then. So many of these tribunals mimic the practices of courts and therefore very soon have huge arrears piled up. It's the same lawyers who appear in courts who also appear in the tribunals, and their habits also continue in those tribunals. So the tribunals exacerbate and certainly do not mitigate the three evils that we spoke of: cost, delays, and uncertainties. Then we have arbitration as the alternate dispute resolution mechanism. All of us know how arbitration can only increase costs, increase delays, because for enforcement of arbitral awards, you come back to the courts. And there are huge delays in enforcement. We've now toyed with what is called court-annexed mediation. The judiciary itself is taking the initiative in training advocates and the district judges in being mediators. It's had limited success, I would say, in some of the metropolises, but not uniform success across the country. And there are certain categories of cases that can never be sent for mediation. The chief among them being of the biggest litigant in our courts, the government. Government will never sit for a mediation because the government's processes do not permit it to take a decision at the table of the mediator. We have Lok Adalats and other ADR processes. I don't have time to go into it, but very often in these Lok Adalats, we use the very three negative things: cost, delays, and uncertainties, to pressurize the person in a Lok Adalat to settle for less. So very often, after waiting 10 years and 15 years in a motor vehicle accidents tribunal, somebody who ought to have been paid a compensation of, say, 20 lakhs is having to settle for as little as 5 lakhs or 7 lakhs. And we tout this as a great achievement for the judiciary. And then, of course, we have the informal legal system. We still have the panchayats that mete out verdicts that can be an acceptable form of constitutional point of view. Then we've had godmen, gurus, community leaders, cult figures, local mafia dons with an impressive criminal track record offering their dispute resolution services. They're all outside the rule of law framework. And therefore, in a failed legal system, people are desperately looking for other avenues.